Today we are covering a bunch of things going on in the Karen Read wrongful death case. Yes, there are new filings in the criminal case that are Proctor involved. He's going to have to wait a minute. There is a hearing on a motion to compel this afternoon. So we're going to cover what that motion to compel is and all the other stuff the judge has had to say, because the judge was like, order. And I'm like, what? Why are there so many orders from the court? The court's like, boom, 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 boom. What are we doing? Why is the judge so over it? Counsel are requested to provide to the clerk by 12 noon on June 12th the following information as to depositions they have presently noticed. Deponent, date scheduled, time scheduled. I want a list of the depots. I have not seen quite this level of micromanagement in a civil case. I don't even know if ever. But that's not all. That was just the first one. The next one is regarding a docket number that has now been stricken from the docket, but we went over. We'll look at it again together. Don't worry. I'm not going to leave you hanging on that because we already grabbed it. This is also from June 11th. Order. Paper number 111 did not include the requisite certificate of service. Any document filed through the court's electronic filing system must include a certificate of service. It is hereby ordered that paper number 111 shall be stricken from the docket. He's not done yet. That was docket 121. Let's go to docket 122. Emily, are we pulling each of these up independently? Yes. Document 122, also from June 11th. Mass Rule of Civil Procedure 7A sets forth the pleadings allowed under the rules of civil procedure. The rule is applicable to captions, signing, and other matters of form of pleadings and apply to all motions and other papers provided for these rules. Such rules do not provide for letters from counsel. Do we all now remember what docket number 111 is? It is hereby ordered that the clerk's office shall not docket copies of letters from counsel. He wasn't done yet. Those three were all on June 11th. The court then filed this on June 12th. The court has now not retyped the entire header and has footnoted the header. Why are we footnoting the header? Order relative to certain filings. The docketing and filing systems, mass courts and e-file, do not accommodate hyperlinks in a pleading providing access to cited material. Any hyperlink to a source document that appears in the text of a file document shall include the complete citation. I think this is reasonable. Preceding the hyperlink, a reference to the page of the paper appendix shall be filed. So you need to file it. If a hyperlink to an audio or video file on the internet is cited, or some other such file is cited in a filing, a separate appendix shall be included in the e-file. The appendix shall list each hyperlink with the corresponding page number of the pleading where the hyperlink appears. A flash drive or external hard drive shall be delivered to the clerk's office within 1 business day of the e-file that clearly contains identified copies of such audio or video file with reference to the page number where such files exist. This is actually fair. It goes on to say, in addition to the e-file, you need to bring a hard copy of the exhibits and separate from one another by offset tab dividers, shall be delivered to the clerk's office within a time period set out in paragraph 2, like the next day. It also says that counsel in the case shall use the email address to email a Word version of all memorandum or affidavits filed, except affidavits relative to 9A and 9C compliance, in addition to filing them through e-file. That's an extra step that the court's like, you also need to file a Word doc via email for the court. So the court filed 4 orders in short succession and has also now asked for a Word doc. And I don't know why the court's asking for a Word doc, not a PDF. June 12, 2026, defendant Karen Read's memorandum of law in support of motion to compel Colin Albert to attend deposition and produce documents pursuant to third-party subpoena. Third-party subpoena means not a party to the lawsuit, right? Not someone being sued. So third-party subpoena, they are a third party, they are a witness, etc. The court is being requested to compel Colin Albert to attend a deposition and produce documents. That seems to be the big problem. As detailed in the attached emails, tell me more. As detailed in the attached emails, what were normal communications between counsel of a subpoenaing party, Miss Reed, and a non-party witness, Colin, devolved into another episode of Gamesmanship. Oh no, not the next episode. This is their perspective of what's happening. I really want to see the emails, and then we'll see the opposing perspective of what's happening, and then we'll get to figure it out. They say Colin Albert was at 34 Fairview the night John O'Keefe died. He had a history of violent tendencies, and specifically, he and Mr. O'Keefe had a series of prior disputes. On the night Mr. O'Keefe died at the house, Colin had been drinking alcohol with his friends, and that drinking party continued at the house late night. The exact time Colin left the house is a heavily disputed fact in this case. Regardless, however, they say when Mr. O'Keefe arrived at the house around 12:30 a.m. on January 29th, 2022, the medical evidence demonstrates conclusively that he was beaten up. And again, this is writing and advocacy. Are there arguments about the conclusiveness of John O'Keefe being beaten up? I still think with head injuries, there are room to make arguments, but this is a wrongful death case. But there are room to make arguments. However, there are some scratches and stuff that raise other questions. Either way, in the immediate aftermath, those individuals at the house, referred to as the house defendants in Miss Reed's federal court action, attempt to cover up their role in Mr. O'Keefe's death. And this is what this entire case is going to be about as to Reed's defense to the wrongful death, which is why this is also intertwined with everything else. Additionally, Colin is tightly connected to both the House defendants and the lead investigator for MSP. Specifically, Colin is the nephew of Brian Albert, who owns the house. Allie McCabe is the daughter of House defendants Jennifer and Matthew McCabe. Brian Albert and Jennifer and Matthew McCabe were all at the house when Mr. O'Keefe died. Colin was also close family friends with Michael Proctor, the conflicted and corrupt MSP investigator, former, that refused to investigate the House defendants in an attempt instead to, quote unquote, pin it on the girl. It annoys me that they keep putting that in quotes because it is not a direct quote. It is their theory of the case, and it causes quite a bit of confusion. I think you guys let me know. For me, I think the pin it on the girl vibes are pretty clear from the overwhelming amount of stuff we have seen said by Trooper Michael Proctor. But this is not a direct quote from anything. He said there will be some serious charges brought on the girl. She's fucked. What about the homeowner? Nope. He's a Boston cop too. There were a lot of things said that gave this impression, but this is their theory of the case. It's an impression, not a direct quote. They go on to say not only was Colin at Proctor's sister's wedding, he was in Proctor's sister's wedding. We saw those pictures in trial number 1. They go on to say that Proctor's mother circulated a public Facebook post in October of 2019 declaring the Alberts are, quote, the Proctor's second family, and included a photo of Colin Albert and his parents among a mountain of evidence demonstrating that Proctor attempted to unlawfully protect those in the house. Proctor's written notes he took early in the investigation show that he knew Colin was in the house that night. That's interesting. But when he prepared his quote unquote official report, he omitted Colin's name to hide his involvement that night. Despite being present at the house after midnight on January 29th, 2022, Colin was not interviewed by MSP until July 18th, 2023, which is fucking wild. In a report of the interview, Proctor writes that Colin was picked up shortly after midnight by Allie McCabe, revealing for the first time the presence of yet another witness, Allie, and yet another vehicle, hers, outside the house that was never investigated. Despite this quote-unquote new information, Proctor failed to confirm Colin's statements by seizing his cell phone or Allie's or pulling carrier records. He just took Colin's word for it, or rather, took his father, Chris Albert's, word for it. On September 1st, 2023, Trooper Buchanan authored a 6-sentence report stating that he had contacted Colin, quote, in an attempt to have him turn over text messages he had captured screenshots of between Allie McCabe and himself on January 29th, 2022. There is no report memorializing what prompted Buchanan to call Colin, how Buchanan had obtained Colin's phone number, or how he became aware that Colin was suddenly in possession of text message evidence. What one would hope to see in an investigative report is exactly that. You would expect to see because of this, I did this, then I asked this. I learned of A, which led me to B, and then I asked C. Also, get the carrier records. Get a cell phone download. Nobody wanted to do this. In his report, Buchanan goes on to say that he contacted Chris Albert because Chris, not Colin, was in possession of the screenshots of Colin's and Allie's text messages. These messages, were shared by the Norfolk District Attorney's Office as mere cut and paste screenshots of texts into a PDF document. They contain no metadata to confirm their accuracy, nor is there any audit trail of when and how Chris Albert came to be in possession of Colin's messages. Look, in 2026, we cannot just use screenshots of messages in court. They go on to say that data downloaded from Life 360 on Jennifer McCabe's phone shows timestamp notifications of Allie McCabe's arrivals and departures from addresses throughout the early morning hours of January 29th. They go on to say not only does the Life 360 data prove that Allie McCabe did not drive straight home after dropping off Colin, as she told Buchanan in her August 25th, 2023 interview, more importantly, the data shows no evidence of an arrival or departure from 34 Fairview or Colin's house at any time on January 29th. What? Why didn't that come up in the first trial? I'm putting a big old asterisk on this. I have a lot of questions. I don't have the raw data to look at. We have advocacy here. I'm waiting to see what the opposition says, but this is a big area of questions that I have questions on. They say for these reasons and more, Colin has relevant information about what happened the night of January 29th, 2022, his communications with the House defendants and others concerning John O'Keefe's death and Proctor's investigation. Right. I mean, did Jen McCabe text Allie and say, hey, come get Colin? I've got questions. They go on to say Ms. Reed's attorney served subpoenas upon Colin and then attempted in good faith to narrow the scope of the subpoena after objection. On February 11th, 2026, Reed's attorney promptly served a notice of taking deposition for Colin on April 29th. See notice of taking deposition. On April 21st, Ms. Reed's attorney also properly served a subpoena upon Colin, attached as Exhibit B. The subpoena required Colin to attend a deposition and bring with him documents related to the case. Specifically, the subpoena required production of documents in Colin's possession related to the MSP investigation. I wonder if he even has any on the investigation. Ms. Reed's criminal and civil cases and his communications with MSP investigators. His communications with the House defendants and others directly associated with the case. On April 27th, the attorneys who represented the House defendants identified that they were representing Colin. All of this is a terrible idea. And they served a Rule 45 objection on Reed's counsel, including objecting to the scope of the request for the production of documents. And then they've got the email there attached as Exhibit C. One of counsel's primary objections was the scope of the request for communications with his parents from January 29th to the present. However, Colin's counsel did not claim that the subpoena was ineffective. Right, he was objecting to it. I'm curious to see what happens next. That same day, April 27th, Reed's counsel requested a Rule 9C conference relating to the objections and wrote that it makes sense to take Colin Albert's deposition after the documents are produced and agreed to reschedule the deposition so they could address the objection. This seems reasonable. Hey, we have objections about documents. Hey, we need documents before depo. Okay, we'll get you the documents before depo, but then we need to reschedule the depo. Okay, we'll reschedule. Can you get me the information? Ms. Reed's counsel did not, quote, withdraw the subpoena or cancel the deposition. And Colin's counsel did not take the position that the subpoena was ineffective. Oh, they must take that position now. They've said it twice and it's underlined both times. Rather, on April 28th, counsel for Ms. Reed and Colin conducted a 9C conference. 9C is just the rule that requires them to have the conference to narrow the dispute concerning the request for documents. During that conference, Colin's counsel did not take the position that the subpoena was ineffective. Well, when did they start arguing it? Because it's clear that the foreshadowing is strong. Nor did Ms. Reed's counsel withdraw the subpoena or cancel the deposition, but they did discuss the possibility of narrowing the scope of the subpoena. That's what they're supposed to do. As a result of the conference, the very next day, April 29th, Reed's counsel provided a proposed narrowing of the subpoena's requested documents, specifically addressing the main concern, which was Colin's communications with his parents. Specifically, Reed proposed to narrow the request to a 4-month period immediately following Mr. O'Keefe's death, and counsel asked for a response to the proposal. Rather than respond in good faith, Colin's counsel began efforts to thwart the subpoena entirely. For 3 weeks, Colin's attorney entirely ignored Miss Reed's April 29th request. Things start to go off the rail. Ignored the request to agree to narrowing the subpoena for 3 weeks. And the court's like, why is this all taking so long? This is why. Miss Reed's counsel then reached out again on May 19th, specifically asking for a response to the narrowing, the production of responsive documents, and the deposition dates in June. On May 20th, Colin's counsel wrote that Miss Reed's proposed narrowing was still, quote, not appropriately scoped, but did not address which paragraphs, what documents would be produced, or what deposition dates. And then they say, underlined, Colin's counsel did not take the position that the subpoena was ineffective. In response, on May 20th, Reed's counsel inquired about which paragraphs were not, quote, appropriately scoped, and asked again for deposition dates in June. At 10 p.m. on May 20th, counsel wrote that they had conducted, quote, a reasonable search, but they were unwilling to produce any responsive documents. Oh dear. Worse, they say, Colin's counsel stated for the first time that Colin would be out of town indefinitely after June 2nd and would only be available on May 28th or 29th. There's a 3-week delay, and then the response is, we're not giving you the documents. You have 9 days to take his deposition. Good luck. And they say again, notably, underlined, Colin's counsel did not take the position that the subpoena was ineffective. On May 21st, Reed's counsel advised that he would be out of state on May 28th and 29th and inquired about dates in June and why Colin couldn't come back for any dates in June and why notice wasn't given before 10 p.m. on May 20th that Colin would suddenly be gone indefinitely. Sounds kind of like Proctor's unavailable indefinitely. He also asked more questions about the reasonable search conducted for the documents and what responsive documents they had for each category that they were contending was unduly burdensome and overly broad. Colin's counsel did not respond on May 21st. Rather, the very next day, after Reed's counsel advised that he was, quote unquote, out of state on May 28th, plaintiff's counsel sent an email on Friday afternoon of Memorial Day weekend, May 23rd, stating that he had communicated with Colin's counsel that Colin's counsel had accepted a subpoena for Colin's deposition on May 28th. No. And he intended to proceed with a deposition on that date and then attempted to serve an invalid notice of taking deposition among the parties. No. No, you didn't. This is ridiculous. Okay, let's back this up. Reed's attorney and Colin Albert's attorney are going back and forth about the depositions and when it's going to be taken. And then plaintiff's counsel, Diller, parachutes in and is like, we're going to take the depo. They had never noticed the depo. This is ridiculous. Here's why. The party that noticed the original deposition is the party that should be taking the deposition, the defense. The plaintiff coming in and trying to yoink the deposition to a time when the counsel who's taking the deposition is unavailable is such crazy fuckery. And I am very curious about the communications that happened between plaintiff's counsel and Colin Albert's counsel to come to the date of the 29th, because it seemed that they were just parachuting in to cut Reed's attorneys out and be like, oh, well, you're not available. Too bad, so sad. So plaintiff's counsel sent an email Friday afternoon saying that he had communicated with Colin's attorney and that they had all agreed together without Reed's attorneys being involved. They had all agreed together that they were just going to do the depo May 28th, cutting Reed's attorneys out of the conversation entirely and setting it for a day that counsel knows that they're unavailable is fuckery. Absolute fuckery. And it's not proper notice. You need at least 7 days notice to the other party because you can't cut the attorneys out of the process. Per the plan, an hour after plaintiff's counsel's email, Colin's counsel then responded to Miss Reed's counsel's May 21st email and took the position for the first time that Miss Reed's subpoena was now ineffective. And that's why they kept bringing it up. So we're not bound by Reed's subpoena. That's why they're now arguing it's ineffective, to try to get out of the obligation to Reed's subpoena, it seems, and then get into the obligation for plaintiff's subpoena. There's a lot more information. They go on to allege that he did not explain why the change in position or what occurred between May 21st and May 22nd that suddenly made it ineffective. Additionally, he refused to provide any dates in June, explain why Colin could not come back for a deposition after June 2nd, nor describe what, quote, reasonable search he conducted or what documents he obtained related to that search. He did, however, reconfirm that Colin did not intend to produce any responsive documents. We're not giving you the documents. We're not attending your depo. And now we're going to go play patty cake with plaintiff's counsel and do a depo with them. The subpoena is not ineffective and the court should compel Colin to comply with it. Colin's counsel's communications on May 22nd is quite revealing in its refusal to explain anything about the, quote, reasonable search that they claim that they did and what responsive documents they have, which is what you have to do generally if you say that you have responsive documents and you're not providing them. In civil litigation, you have to list the responsive documents, then your objections or exceptions. Like, hey, this document is responsive, but it's attorney-client privilege. Or, hey, this document is responsive, but this objection. You can't just say there's responsive documents, we're not giving them. There's a lot more process that has to happen there. They go on to say, indeed, they intentionally obscure addressing the responsive documents they found, despite making arguments about overly broad or unduly burdensome. For example, if there exists 100 text messages in response to the subpoena, that's not overly broad or unduly burdensome, but they refuse to provide that critical information. Rather, when pressed, they suddenly call the subpoena ineffective and then peddle the May 28th date to plaintiff's counsel once they knew Ms. Reed's counsel, who is prepared for this deposition, will be out of state. The court should not countenance this type of conduct. And a quick break to talk about our case brief sponsor, Incogni. You've heard me talk about Incogni on stream, here on Case Briefs and podcast and everywhere else, because so often we're looking at cases where personal data becomes a topic of conversation. At the end of May, people were using Meta's own chatbot function to gain password reset access to people's Instagram accounts. So every day, it seems like it's something new where you can get locked out of accounts, have other people accessing your personal information, and you just need someone to monitor it all for you. And that's what Incogni's for. One of my favorite things about Incogni is that I can set it and forget it, not just for myself, but for my family members, because they go after the data brokers that are continuing to spread and sell your information all around the internet and start taking it down. You can see the progress of what's being requested to be taken down if you need to take more action to get something taken down. And they even have a custom removal feature, which means if you need a little bit more help with something specific, they've got your back. You're not just left hanging. So if you're ready to protect your privacy and start getting your information off the internet, Incogni is what I trust with my and my family's information, and I think it will work for you. Plus, if for any reason it doesn't, they have a 30-day money-back guarantee. So if you're thinking it's time to take back your personal data with Incogni, you're right. Now is the best time, because if you go to incogni.com/Emily and use code Emily, you'll get 60% off annual plans. Now let's get back to the brief. This is from Rosenberg to Chris, the attorney for Colin Albert. Chris, thanks for the call yesterday. I thought through your team's proposals on consolidation and the subpoena to Colin Albert and have discussed them with our group. We do not agree to consolidate discovery in your client's defamation case with the O'Keefe's litigation. Interesting. As we discussed, we are already well down the road in discovery in that case, the wrongful death case, with almost all documents produced, multiple rounds of interrogatories and answers exchanged between all parties, and over 20 depositions scheduled in the upcoming months. Also, Judge G has been insistent that we do all we can to stick to the existing discovery deadline in August, and I don't believe he would be inclined to allow consolidation that would necessarily require a significant extension of the deadline. They're asking to kind of merge discovery, but the discovery dates haven't even begun yet in the new actions. So merging discovery would slow the older case down to the pace of the newer case. And I can understand why they're not inclined to do that. Also, although I know that you weren't yet involved in the case, your clients previously resisted our efforts to make these proceedings more efficient by bringing our claims against them in the O'Keefe's case last year. Then when we filed those claims in a separate Superior Court action, they removed it to federal court, preventing any chance of consolidation. We do not think now consolidating only your affirmative claims, which your clients opted to bring in yet another Superior Court proceeding rather than the existing federal case, would be efficient or fair. I thought they were just talking about consolidating the discovery. They're talking about consolidating all of the claims as well, which means taking all the claims from their defamation case and bringing them into the wrongful death case. You could take the defamation case perhaps as counterclaims in the other case, but now they're like, oh, now you want to consolidate them? No, we're not bringing your client's defamation claims into the wrongful death lawsuit. I agree with their assertion that the judge at this point would be disinclined because the discovery cutoff is in 2 months. This would extend the case probably 1.5 to 2 years. We do not think now consolidating only your affirmative claims, which your clients opted to bring in yet another Superior Court proceeding rather than the existing federal case, would be efficient or fair. Attached is a proposed narrowing document subpoena to Colin Albert, particularly the portion of the last request seeking communications with Colin Albert's parents, as you requested in our 9C call. Please let us know if you will agree to produce the documents responsive to these narrower requests. And that seems to be the email that didn't get a response. That's April 29th. Thursday, May 21st. This is from Waters to the attorneys, including Kieran. Kieran, 1, you must have missed my early response to Chris's email. I've placed it below chronologically for clarity in our communications. 2, your statement below that no further document exists and that you are willing to produce at this time is, of course, the exact issue with which we are concerned. 3, please describe the reasonable search you claim to have conducted. 4, please produce all responsive documents you are willing to produce at this time. 5, related to the responsive documents that you are not willing to produce, please identify what they are, including, are there any responsive documents relating to the investigation, criminal trials, civil actions? How many? Regarding Colin Albert's parents, what is the volume? This is what's required by the rules. Were there any responsive documents that you are not willing to produce relating to, and then they list those items, including conversations or communications with literally everything going on with the criminal case. Then they ask about the deposition. Please provide the additional dates in June. I look forward to your response. Exhibit F. This is from May 22nd, from Diller to all the attorneys, including Rosenberg. Counsel, 4:02 p.m., Friday, May 22nd. Counsel, please note the following. Tuesday's deposition of Makowski, Mike Wazowski, of Makowski is off, while the O'Keefe and Reed teams confer on Reed's objections to the matter. We are notified that Ms. Collins and Ms. Bombardier need to reschedule the Tuesday or the Thursday depositions. Given that all parties were already blocked for the day and our need to move the depositions forward, we investigated and discovered, oh, that's shady. Given that we already have all this time blocked aside, we investigated and discovered. That's just disingenuous. We discovered that Colin Albert's deposition was canceled by the Reed team previously and never renoticed or subpoenaed to date. That's not accurate. Albert's counsel has agreed to accept the subpoena and appear next Thursday at his counsel's office for deposition. See attached. Friday's deposition remains on calendar and has been confirmed and is going forward. Have a nice holiday weekend. I look forward to seeing all of you next week. Friday, May 22nd, 5:36 p.m. From Kieran Murphy to Charles Water, Chaz. Respectfully, I decline to engage in a line-by-line dissection of our responses and objections to the subpoena. The subpoena was issued to a non-party pursuant Rule 45. As you are aware, non-parties are afforded specific protections from undue burden under Massachusetts Rules of Civil Procedure. Well, I guess this is what they're going to be fighting about today. We have made our position clear that this subpoena exceeds permissible bounds and violates those protections. Moreover, we have now inquired twice without receiving any response regarding the relevance of Colin Albert's testimony to the wrongful death action. I mean, one of the defenses in the wrongful death action is that, A, John O'Keefe wasn't hit by a car and not killed by Karen Reed. And B, the reason that this is all before the court is because of the way the investigation was done and showing that what Colin Albert was doing or not doing is different than what the investigation said he was doing underlies the defense that Karen Reed was A, framed, or B, not at fault, or C, the investigation is so bad you can't possibly find the wrongful death. But okay. The disposition of that case requires answering a singular question: whether your client is responsible for the death of John O'Keefe. Colin Albert was not present at 34 Fairview at the time of Mr. O'Keefe's death, and you have provided no explanation as how his testimony assists in resolving that central issue. Absent such an explanation, our objections to the subpoena remain unchanged. And then they continue to note that. They say that they've made a good faith effort to reach a compromise on producing different documents. And I have confirmed that only a single text exchange is responsive to these categories: communications between Colin Albert and Allie McCabe regarding the time McCabe picked up Colin Albert at 34 Fairview. That text exchange was used by Miss Reed's criminal defense during Colin Albert's cross-examination and supports our position that it's already in Reed's custody. However, as I previously stated, if for whatever reason Miss Reed no longer has access to that exchange, we're prepared to produce it. We'll give you what you already have. Regarding Colin Albert's deposition, we have received a subpoena today from plaintiffs in the wrongful death suit for his deposition May 28th. Finally, I'm not in a position to provide further detail regarding my client's availability constraints beyond what has already been communicated. Colin Albert will be unavailable for an extended period after June 2nd due to work-related obligations. Accordingly, we look forward to completing his deposition before that date. Oh dear. Non-party Colin Albert's opposition. I'm just curious what their factual opposition is. Reed's motion is, what are we saying? Is of a piece with her cynical, years-long campaign to scapegoat Colin and many others in order to deflect from her own culpability for Officer John O'Keefe's death. Reed's motion is littered with material misrepresentations, thoroughly debunked claims, cheap character attacks, and outright knowing falsehoods that have no place in court filings. Oh shit. They definitely took an opportunity to say, we do not agree on the dispositive issue before this court, whether Reed is responsible for the death of Officer O'Keefe. Colin has virtually zero relevance. The investigation has a lot of relevance, which means Colin Albert has a lot of relevance. It is undisputed that Colin was not present at 34 Fairview Road when Reed and Officer O'Keefe arrived in Reed's car in front of the home. Well, the other side says that is hotly disputed. They say in any event, whatever marginally relevant evidence Colin may possess does not justify the extraordinary burden imposed on him, a non-party, by this subpoena. The subpoena is breathtaking in scope. They did say they were willing to narrow it. I don't disagree that the subpoena was way overbroad. However, that's not uncommon in civil subpoenas, that they are way overbroad and then they get narrowed down. It demands, among other things, all communications with no fewer than 12 individuals. I do think that's too broad, including Colin's own mother and father, spanning over 4 years without any relevance to the death of Officer O'Keefe. Well, the other side's going to say, well, we don't know. It's not relevant until we see it. The requests are not tailored to any discrete issue in the wrongful death action and are not curated to avoid undue burden upon a third party. Colin agreed and did review all his records for communication with police officers pertaining to the investigation and all communications around January 29th regarding the investigation. Colin has no responsive communications except a text exchange with Allie McCabe, confirming that the two arranged for Allie to pick up Colin from 34 Fairview at 12:10 a.m. on January 29th, 2022, a text Reed has had since 2023. Reed's demand for deposition is flawed. They say on April 21st, Reed served the subpoena with deposition for April 29th, commanding his appearance just 8 days later. Despite the short notice third-party witness period, Colin was ready and able to appear. However, Reed canceled the deposition less than 48 hours. That doesn't seem to be what the emails say, that it was not canceled, that it was postponed to get the documents. Oh boy. Well, this is going to be hotly contested. I hate to leave us on a cliffhanger. It is really not my normal vibe. But this is going to be hotly contested. So where are we at the end of the day? Well, the court has put on calendar this afternoon a hearing regarding the motion to compel Colin Albert. Reed's attorneys are saying that Colin Albert's attorney, who is also representing all the House defendants and the other lawsuits, surreptitiously sidestepped their subpoena requests and decided to take a more friendly subpoena from the plaintiffs in the wrongful death case and set it for a time that Reed's attorney was out of state. The response from Colin Albert is that Reed canceled the request for deposition, even though Reed's team said they delayed it to get the documents and that there is still a fight over the documents. Colin Albert's side said, no, you canceled it. So we are going to be deposed on May 28th, which I do not think actually happened. So we are now waiting to see what the court is going to do. Tomorrow on stream, we will be looking at the rest of this request. There is some new information by Reed's attorneys. Colin Albert's attorney says that the filing from Reed's attorneys is littered with misrepresentations. And we've already gotten into the beginning of some emails back and forth with counsel where everyone's disinclined to acquiesce to anyone else's request. And that's what I think we're going to see more of as we get into the rest of these documents tomorrow. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.